Iron Farm Show. It's a little bit of a foggy, cool trip into the fairgrounds this morning. We're glad everybody made it, and we're looking forward to 3 big days here at the Big Iron Farm Show. My name is Don Wick with the Red River Farm Network. We have the rest of our crew here as well. Whitney Pittman, Sierra Doctor, Randy Coonan, of course, doing markets, Jay Rader at the back. We appreciate all of our team making this possible. And also we thank all of our sponsors. It wouldn't be possible with those folks as well. We're going to talk about something maybe we all deal with at time to time, and that's what's going on in some of the legal issues, tax issues, and really the impact on agriculture in rural America. And our guest today is someone that's heard on our airwaves every day, Roger McOwen. He's a professor of agricultural law and taxation at Washburn University School of Law in Topeka, Kansas. You got a big business card, Roger.
Yeah, that's right.
Great to have you here. We appreciate you making the trip north.
Yeah, thanks, Don. Good to be here.
Let's talk about it. Maybe if you don't mind, we start by talking about what's been going on in the Supreme Court, because it seems like it's been pretty active for agriculture. In our region, water is an issue that's pretty important to a lot of folks. And they made some pretty big ruling here as it relates to waters of the United States.
That's right. We had a very big decision on May 25 by the U.S. Supreme Court involving the Sacketts out of Idaho, northern Idaho, and people probably know the case name, know the case by its name. The Sacketts owned a tract of land, just a little bit of the facts, clear up in the northern, kind of that narrow area of northern Idaho. And they bought the lot to build a home on, and it was about 100 yards away from Priest Lake. Now, Priest Lake is a water of the United States. Their lot is not. It's not connected to Priest Lake. There's 100 yards. There's a road, some houses in front of their lot, and then the lake. But once they started to develop it, the government came in, EPA and the Corps of Engineers, and said that you have to stop. We think that's a wetland. Well, this went on. This has actually gone on for 15 years. Oh. 2 trips to the U.S. Supreme Court, and farmers really have a lot to thank the Sacketts for going through all of this, as well as the Pacific Legal Foundation that gave them legal representation without charge, or else they would have never been able to do this. But they first came in, the EPA would not make a final determination as to whether that was a wetland. Well, under procedural rules, you can't challenge that unless the government makes a final determination. So they said, make a final determination. No, we won't do it. So the first lawsuit forced them to make a determination. That got all the way to the U.S. Supreme Court, and the U.S. Supreme Court said a number of years ago, yes, you have to make a final determination. They have the right to appeal something. You can't just freeze them in place year after year after year and threaten them with penalties if they do something, which could be $75,000 per day of violation. And that got to the Supreme Court, and the Supreme Court said 9-0, agency, you have to make a determination. So then the agencies made a determination. They said, okay, it's a wetland. Then you get the second trip to the U.S. Supreme Court, another 5 years of litigation, and finally in May, the U.S. Supreme Court said that the way that the EPA and the Corps were determining what a wetland is, the significant nexus test, was no good. And they unanimously threw out the significant nexus test. Now the twist in this was that while the case was pending, the EPA put out a new rule revoking the Trump rule, which said you had to have a continuous surface water connection, and putting in the significant nexus test, which was the prior rule. And then the court came and wiped that out. So just a couple of weeks ago, the EPA put out amendments to their WOTUS rule, eliminating the significant nexus test in the regulation, putting in a surface connection test, and doing a couple of other things to comport with the Supreme Court opinion. While all that's going on, we had 3 other federal lawsuits that had put an injunction on the clean water rule of the current administration, including North Dakota. It's not enforced in North Dakota. And those cases are still out there. And frankly, I don't know what's going to happen with those cases. So currently, the rule is not enforced in 27 states.
Including North Dakota
including North
and
Dakota.
South Dakota, but you go across the river in Minnesota, it would be.
That's correct.
You wonder why we get confused on all this stuff.
It is confusing. And we probably have not seen the last of this in the courts.
It seemed the terms the significant nexus, or that terminology seemed to be a big part of this last ruling. What are we talking about?
Well, that's huge, because that would say that the government would have jurisdiction even if there were a man-made berm or a dike or some type of structure that was blocking the flow off of your farm that would eventually connect into a regulated water course. And the court said, well, that's not the appropriate test. You have to have continuous surface water connection. So these ephemeral streams, these play of potholes in the pothole region, sometimes have water in them, sometimes don't. Those would not be subject to regulation, perhaps under the Supreme Court's interpretation. Now, I suspect the EPA and the Corps will still probably try to assert jurisdiction in the pothole region of the United States, and then we'll have to litigate that to see if their interpretation squares up with what the Supreme Court has said. But the continuous surface water connection flow requirement is going to remove a lot of ditches from regulation, or remove these ephemeral streams that sometimes have water in them, sometimes don't have water in them. And it will remove the possibility of a spot in a farm field from being connected to something else that's connected to something that eventually flows to the Missouri River, for example. So the Sackett ruling is a very good ruling for agriculture, and I would suspect the administrative agencies were kind of drugged with their heels in the ground, forced to make that amendment, and that they'll try to find a way around that.
And you talked about the lawsuits with North Dakota and those, 27 states
27
in total?
states.
We have no idea how that hangs out there?
I don't know what's going to happen with those, because we have the Supreme Court opinion. We now have an amendment that purports to conform to the Supreme Court opinion. So do we still need the cases or not? I don't know. I don't know what's going to happen with those three cases.
The other big case coming out of the High Court was Proposition 12 out of California, dealing with really housing standards for pigs and veal calves and chickens. What did that one mean?
Well, that one came out a couple of weeks before the Sackett opinion, and again, very significant opinion, and I feared that this one was going to be decided the way it was going to be decided, because I was not convinced that the arguments were very good. I think they could have argued it differently and perhaps got a better result with two of the justices, and that's how it turned out. In that one, what you had, of course, was California coming up with a Proposition 12, that was set to take effect, and now it's been delayed. It will take effect January 1, 2024, that says if you don't raise your hogs in accordance with the way we want you to raise your hogs in whatever state you're in, whether it's North Dakota, South Dakota, Iowa, you can't have access to our market in California. In other words, you can't sell pork products in California. The problem with that is California consumes about 13 to 14% of all pork products sold in the United States, but they don't produce hardly anything. They virtually have no pork production in the state of California, so their rule doesn't impact their producers. It has what we call almost a 100% extraterritorial effect. The question was, is that constitutional under what's known as the Dormant Commerce Clause? When Congress is silent in terms of regulating something, then the states can do it. That's the Dormant Commerce Clause. It's not in the Constitution, it's kind of laying there dormant. But the issue was we had for certain two justices that don't even believe the Dormant Commerce Clause exists. Now we know that there are three, and a couple of others that weren't going to buy the extraterritorial effect argument. So there were five right there, and that's how this opinion shook out. And so it really raises the question in terms of retaliation by other states. For example, the state such as Iowa that doesn't raise any almonds, can they pass a law that says, California, you can't sell almonds in the state of Iowa unless they are hand harvested instead of shaken? Because we like trees. We don't want to harm the trees. I mean, what's the end game on this? That's the concern that I have.
I think we've seen Massachusetts has done some things on a similar proposition. I think New York, when you get kind of that patchwork, it almost gets to be unworkable.
It does. And I wonder if, and I know there are different views on this in agriculture, but I wonder if maybe an answer would be putting an appropriate label on pork products, for example. A label that says these products were grown not in conformity with California's standards. These were raised by the evil Iowa or North Dakota standards. Let the consumer decide. I don't know.
Yeah, that would be different. Was the court really trying to push it back to Congress to federalize this and make it a decision there?
That's a good point, because in the opinion, one of the justices in a concurring opinion said this was really up to Congress. Congress can legislate in this area, and in fact, we have this case because they haven't.
It seems like a lot of these cases that have maybe an impact on agriculture come out of the appeals court, out of the Ninth Circuit in San Francisco. Explain to me why that seems to be the route that everything comes out of.
Well, because a lot of the activists that bring these cases tend to focus on California, and they can get legislation such as Proposition 12 through the California legislature, where they wouldn't be able to do it in other states. And so you have different views in terms of agriculture out west on the coast. And you see this on the East Coast as well as the West Coast. But you're right, a lot of these do start in the Ninth Circuit. Of course, California is part of the Ninth Circuit. And historically, that has been the most liberal circuit of the 9 circuits, although that has changed somewhat. We have some new judges on the Ninth Circuit. It's not as radical as it has been in the past. We actually do see some sensible opinions coming out of the Ninth Circuit now, particularly on the tax side of things.
I think for those of us in agriculture, we focus on things that are based in science, and it looks like, to me at least, a lot of these social issues are having more precedence when it comes to the courts. Is that fair?
Yeah, I think that's probably a pretty good summation of that. There's a whole, I don't want to get into the weeds on this, but there's a whole thought process in law that kind of gets into the way that society should be ordered. And that finds its way into the thinking of some of these judges. And it's kind of extra constitutional in terms of their interpretation. And that's why you see some of these things. And there historically has been a prevalence of those judges on the Ninth Circuit, and that's why a lot of these cases that the interest groups and the activist groups start, they focus on the Ninth Circuit to try to get a favorable opinion.
We should take note, got microphones out. If you have a question, just give Sierra or Whitney a nod, and we can get your own questions answered during our session here. Talked about WOTUS, Prop 12. Do you see other things on the horizon that may hit the Supreme Court?
Well, we had another Supreme Court opinion came down in June. It was from Minneapolis, the St. Paul area, Hennepin County. And that was, again, a 9-0 opinion. There were 12 states that had this type of law that was at issue in that case. And what it was a situation where an older lady had a condominium in Hennepin County and got behind on her taxes, and the county foreclosed, sold the condominium at auction, and then not only received enough to pay the tax bill, but then kept the difference and didn't remit the difference over the tax bill as to what they received on sale. And that, the Supreme Court said, was unconstitutional. That's a taking of her property. And we saw a similar thing happen under Nebraska law with respect to a ranch near North Platte, Nebraska, where through various circumstances, an elderly lady, her husband had died, she's got the ranch, she ends up in a nursing home. Through a series of issues, her son declined to be the trustee of her trust. It goes to a bank. Nobody told the IRS where tax information should be flowing to now that mom's in the nursing home. It kept going to the ranch. It wasn't going to the bank. And lo and behold, the property taxes on the ranch don't get paid. And so the county comes in and sells the ranch and, again, bags the proceeds. And this was hundreds of thousands of dollars. The tax bill was very small. What they received was large, and the county kept it. And the court said they could do that under Nebraska law. Now the Supreme Court has said you can't do that. And so these 12 states that have these type of statutes are going to have to change those rules. So that had an agricultural impact there, and that also impacted a farm in Massachusetts. So that's a very important opinion of the Supreme Court. And we've got some in the pipeline that we'll have a couple of very significant Supreme Court opinions next year that impact agriculture too.
How do you mean?
One of them has to do on something known as agency deference, the way the courts view what an administrative agency says in terms of how they interpret the governing statute. For example, the Corps of Engineers, the EPA, how they interpret the Clean Water Act. The standard has been for about 40 years now that the courts give the administrative agencies extreme deference. And what that means is if you're challenging an agency determination, you have a very high threshold to overcome in terms of your burden of proof. You have to show that the agency, whether that's USDA or EPA or whoever, acted arbitrarily and capriciously. And that's, basically nowhere, they did something that cannot, under any reasonable interpretation, be within what the Congress intended by the underlying statute. And I think we'll see a change in that deference standard. I think they're going to probably eliminate, if not eliminate, significantly diminish Chevron deference. And the agencies are going to have to do a lot more work to more closely fit their regulation with the statute. We've seen that on a couple of cases over the past 2 or 3 years, and I think the court is indicating they would like to get rid of that doctrine. One was the major questions doctrine. We had a case a year or so ago, very important to agriculture, where the court said that, people might remember when, before he became president, Obama made a comment saying that he would eliminate the coal industry. Well, when he got elected, he realized he couldn't do that. He couldn't get the bill through the Congress, and so he instructed the administrative agencies to write a rule that basically would make it so cost prohibitive to keep producing coal-generated electricity that they would have to shut down. Well, that found its way in the courts, and just a couple of years ago, after about 7 years of litigation, the court said, no, that's something that affects national energy policy. That has to come through the Congress. That's a major question. That's chipping away at deference right there. They did not give the agency deference on that. So to me, that's an indication that the court, when they have the Chevron deference issue squarely in front of them, they're probably going to change it. But that's kind of one that a lot of agriculture really didn't pick up on. I did some writing on that. I've done some radio programs on major question doctrine. That's a big one when the court said, no, we're not going to give you deference on that because that's an issue that affects the entire country. That's got to come through the Congress. Could that impact some of the issues we're dealing with? EPA is the one that comes to mind for me in some of their decisions that they're making? Yeah, it could. Anytime any government, the federal government agency or a federal government agency gets into an issue that has nationwide impact, what the court is saying is that that could involve a major question, and the agency, you don't have the authority to do that. The Congress has to write the rules on that. You can't just change the way energy is produced in this country by regulation. That has to come through the Congress. So anything like that, the court would not give the agencies deference on. There seems to be certain issues that are never ending in court. WOTUS has been one that's been ongoing in this region. Status of the gray wolf seems to be an issue that's one time it goes on endangered species list and the state's right gets pulled off of that. It just, how does that work out? Because it seems like there's never a final decision. Well, we could take another example. In Kansas, we deal with the lesser prairie chicken. Same thing you have with wolves in other parts of the country. We've had that ongoing for 30 years. And what the administrative agency has done said, well, now we have a northern habitat and a southern habitat. And we've got several ranches in Kansas that are challenging that because you get endangered species in a large proportion of their habitats on private land. And so now you have the government regulating private land. So it's a big issue for farmers and ranchers. That's an ongoing issue. So we get issues like that continue to go on. The WOTUS issue has gone on for 40 years. And it changes with whatever political administration is in power at the time and what the politics of the issue are. There are tax issues like that all the time. You get questions now as to what's going to happen with the tax laws when we get to 2026. I don't know. Tell me who's going to be in power at that point in time because it becomes a political issue, and so we continue to have these issues in the courts because of the politics. We had an issue in our region in Grand Forks when there was a Chinese company, Fufeng, that was going to put in a corn processing facility, and it ultimately got international headlines, and Congress got really involved in that whole session as well. I think it's likely going to be some language in the new farm bill that's going to be dealing with foreign ownership of farmland. That's kind of how it transitioned into. How do you see this all coming into play? That's a big issue, and a number of states just this year in their legislative sessions have enacted foreign ownership restrictions or have taken existing law and strengthened them. In fact, in about 10 days, I'll be testifying before the Kansas legislature on a bill that they are considering on foreign ownership. Interesting that you would ask that, because just a couple of weeks ago, we had a federal district court in Florida. Florida, this legislative session, enacted a pretty strong foreign ownership law. And it gets at people that are from China, that are domiciled in China and or have citizenship in China, or other countries of concern is the way that the Florida bill is worded. And so that would include Iran, Iraq, Venezuela, the Maduro regime down there, North Korea, specific countries. If you are a citizen of that country, or you're domiciled there, or you're domiciled here, but you are not a U.S. citizen, you're still a citizen there, then you can't own agricultural land in certain areas. It's focused on your alienage, your citizenship, where it's not focused on race, it's focused on where you are a citizen of. Well, immediately when the bill was signed by Governor DeSantis in May, I say immediately, within 2 weeks, it was challenged by 4 Chinese individuals in a brokerage company that was owned by Chinese nationals. And just 2 weeks ago, the federal district court in Florida refused to enjoin the law. They said it's not unconstitutional because it's not race-based, it's based on where you are a citizen of. The court said, the judge said, I could be restricted by this if I were a citizen of one of these countries, and it has nothing to do with race. It didn't violate the supremacy clause of the Constitution because we have a federal reporting law, the agricultural, it's AFIDA, what is the Ag Federal Something Disclosure Act, Investment Disclosure Act, and the court said, well, it doesn't, the state laws don't conflict with that because Congress would have expressly preempted any state law in this area, and they didn't do that. So that's just a reporting law. States can have their own restrictions. It didn't violate due process. It didn't violate equal protection. It wasn't race-based. They had notice of it, and it didn't violate the supremacy clause. So that's a pretty good opinion for states to model legislation after what Florida has done, because now we have a federal court that said, I'm not going to enjoin this law because I don't think you're going to win on the merits. Now, they can take it to the merits. They can go on. The case doesn't end, but this court is saying, I don't think you're going to win. So I'm not going to stop the enforcement of this law while the case is pending. That's a pretty thorough opinion by a federal district court judge.
In agriculture, we've got a number of ag companies that are owned by, have Chinese ownership. I look at Syngenta or some of those companies.
Smithfield.
Exactly.
Yeah.
And in, say, a Syngenta's case, you have research plots or research farms, those kind of things. Are those considered in these state, what's been done in the state legislatures?
Yeah, the answer on that one is it depends. It depends on how the state law is worded. How far down in the ownership structure do we drill to determine whether we have a violation or not? So where are they setting the violation at? That's a policy decision to be made by the legislatures in each of those states. Are we looking at the top tier, or do we look at sub-ownership tiers of that same entity? And that just varies from state to state.
Let's switch gears maybe over to the taxes side. For agricultural tax issues, what do you see some of the biggest things that should be top of mind for our farmers today?
Big issues right now, some of them are tied into economics right now. What we're seeing is, of course, the USDA projection that just came out is that net farm income is going to be down about 25% this year compared to last year. So that indicates to me that farmers need to be looking at utilizing farm income averaging, and managing those income tax brackets over a 3-year period to see, because you don't want to leave any dollars on the table when income's going to be down and your expenses are still high. So they're indicating, I saw the USDA data just last week, they're indicating that production costs are going to be up about 7%. That includes housing costs because interest rates are up. All your input costs are up except fertilizer, which is steady compared to last year, which was up from previous years, so it hasn't gone up again, but everything else is up. So you've got higher expenses, you've got lower cash revenue, cash commodity sale revenue down about 7%, or down about 4%, and net farm income down about 25%. So Do we need to be looking at not deferring income to pull income back to the current year to fill up a tax bracket? We don't want to leave a tax bracket unfilled, so maybe we can pull that back in before it gets taxed at another amount. Do we want to do income averaging? What are we doing with prepaying expenses? Is this a year to prepay or not prepay expenses? There's a whole host of issues to think about that are tied into the economics. And then we have the other issues that are trending, and I would say a trend in parts of the Dakotas, Minnesota, Iowa, but I'm getting questions from literally all over the place on this because some people are learning about it for the first time, is deducting excess or residual soil fertility. In other words, when I buy a farm, I want to allocate as much value as I can to items that are depreciable. So if it's got buildings on it, if it's got a grain drying setup on it, if it's got fences on it, or if I'm in a part of the Midwest or the Eastern Plains that has field drainage tile, I want to allocate value to that and set it up on a depreciation schedule and write it off. Well, the thought process has been, if I buy a farm and the previous owner put soil conditioners on there, fertilizer, and other conditioners on it, that has a value to it. In other words, I'd pay X if it didn't have those components, those nutrients in the soil. I'd pay Y if it does. And so I want to take that difference and I want to allocate some of the purchase price to that and depreciate or amortize that over 3 or 4 years. And that's a technique that a lot of people are starting to pick up on. There are some firms out there that are pushing it hard. Some are, in my mind, too aggressive at it. But that's kind of one thing that's big in agriculture right now with respect to residual soil fertility.
I think you alluded to it earlier, but in 2020, cut in half, right? We go from 12.9 million for individuals, 24.8 for couples right now. That changes dramatically in 26, right?
Yeah, we're at 12.92 million per individual on the federal estate and gift tax exemption. So about almost 26 million combined for a married couple, and that'll adjust up for inflation next year. It'll adjust up for 25. This is if Congress does nothing. And then starting in 2026, that 2017 law, which was part of the Trump tax legislation, that will go to 5 million in 2011 dollars. So it'll be indexed for inflation. And most of us think it'll probably be about $7 to $7.5 million. But keep in mind, we're at 12.92. The adjustment from last year to this year was $860,000. I think the adjustment to next year will get us to about 13.5, and the adjustment in 2025 will take us probably right around 14 million per person, and then we're going to go basically to 7. So you're right, it's going to get cut in half if Congress does nothing. That's what happens if Congress does absolutely nothing. Now, the question is, will they do anything? And again, it depends on who's in power at that time.
Yeah, a lot's going to depend on the next round of elections, right?
And that may not be as big an issue, actually, Don, for farmers as what they'll do with income tax basis. If you remember a couple of years ago, there was a push to eliminate or modify income tax basis at death, the Bernie Sanders bill, for example. And other legislation that would have taxed capital gains even without a sale of the asset, just tax the appreciation in the asset without a sale. So you inherit an asset, let's say I die, leave you an asset, and it's got inherent gain in the land of $5,000 per acre. You'd have to pay that even though you didn't sell the land. So they were talking about that a couple of years ago. That any change in the basis rule that would eliminate or diminish step-up basis would be really hard for farming operations. Most farming operations are not subject to a state tax. More would be if that exemption comes down, but the basis issue is a big issue for everybody.
When it comes to taxes, are there some different advantages, what kind of business structure you're in, if you're an S Corp, C Corp, whatever you may be?
Yeah, that's another good point, and that particularly with farming operations, if you have a large farming operation that can qualify for more than one government payment limit, which is generally $125,000, then you want to be a general partnership, because USDA FSA has a rule that says that if your operating entity has any type of liability, so if it's a C Corp, an S Corp, an LLC, a limited partnership, any type of liability limitation, you get one payment limit. no matter how many payments you're potentially eligible for. Let's say you could be eligible for $500,000 of payments. You're going to get 125, and then you're going to have to spread that 125 over the owners of the business. But if I'm a general partnership, and my substructure, for example, might be, it's mom, dad, 2 kids, each having a 1/4 interest in the general partnership. It could have LLC 1, LLC 2, LLC 3, LLC 4. But my operating entity is a general partnership. I could still get that $500,000 worth of payment limits. And if net farm income is going to be down, government payments are going to be down too, but we don't want to leave government payments on the table. So we want to be structured in a way where we can maximize government payments. And that's one area where the structure question comes in. And it also comes in when you're doing succession planning or transition planning. But every situation is unique. Every family structure is different. Their goals and objectives are different. And that's what has to drive the process in the way that the business is organized.
Probably good to have kind of a team that you work with, whether it's your CPA, your lawyer, have farm management folks all sitting at the same table.
Exactly. I have pushed for many years, and I tell my law students this, when you get into practice, adopt what I call the Mayo approach to legal practice. And if anybody's been to the Mayo Clinic compared to the way that a hospital operates, all of the doctors that are consulting with you on your physical problem, they all work together. That's not the way it happens at many hospitals. You have a doctor for this and a doctor for that and a doctor for this, and none of them talk to each other. And if you want to know what's going on, you talk to the head nurse in many situations. So if we have the CPA there, we have the attorney there, we have the farm manager there, we have a financial consultant, we have an insurance agent, all of those people bring something unique to the table. And of course, the attorney's kind of the quarterback and drafts everything and puts it all together. But the attorney may not be up on the tax issues. And the CPA or the tax professional needs to know what the legal issues are. And then the financial consultant spots financial issues along with the farm manager. And yes, it costs more for that approach, but I think that better serves most farming operations to be represented that way, with all the professionals helping them, everybody working for the same goal.
It seems like things change year by year. It's got to keep you busy on the road, doing some of these educational type programs.
Oh, yeah, the tax laws change constantly, and we've just got a brand new partnership audit regime. I had to deal this morning before I came over here with a question from a CPA in Illinois that had typical situation, an informal partnership with dad and son and dad's brother. And then dad died. They were filing a partnership return, but there's no partnership agreement. Nobody knows who gets what. The will was unclear. So now you've got grain, you've got livestock, you've got equipment, and the CPA is trying to figure out, now he's getting this secondhand because it was dumped in his lap. I'm seeing the partnership returns that were filed. They missed the basis increase election, which is a special election if you have a partnership to increase basis. Am I too late to make the election? And that's a question I had to unwind this morning. But we see all these informal arrangements all the time, and if we could just get people to put things in formalized writing, it can really, that's a good first step on a lot of the planning issues.
Is that like one of the biggest mistakes we see out there, that we're not documenting some of those kind of things?
With respect to business structures, operating informally, are you in a partnership or not? Well, that has legal implications. It has tax implications. My lease arrangements. Do I owe self-employment tax on my lease? Well, you don't have anything in writing. Are you sharing income and expense? Are you bearing risk of production, risk of price change? We can avoid a lot of the questions that IRS can raise if we just get these agreements in writing.
And a reminder, if folks have questions, give us a wave and we'll get those questions answered. Let me switch back to some of the legal type issues.
He's got a question.
I'm sorry, Whitney, you got a question back here?
Yeah, my question is on estate tax. If you make a large contribution under the current law, and report it to IRS, will your if they cut it in half in year 27, will you were talking 7 million? Will your 7 million be reduced by the?
Will it come back?
Right.
Yeah. No, that's what we call clawback. And in case you couldn't hear the question, what he was saying was, if I make a gift now when the estate tax exemption is relatively high, and then at the time of my death, the estate tax exemption is low, if I'm reading you right, will the IRS claw back the taxes that they didn't collect at the time the gift was made because the exemption was high? The answer is no. The IRS has come out and said we will not implement what they call clawback, except in certain situations. If it's an outright gift, the answer is no. If it's a life estate type remainder arrangement, or you're carving out special types of retained interest, then the answer could be yes. But that really gets us into the weeds on certain string sections of the code. So if it's an absolute outright gift, the answer is going to be no, if the exemption comes back down.
Roger, are there any other common tax issues associated when we have a passing of a farmer or transition of a farm?
Yeah, let me give you one it came out of Nebraska about 5-6 years ago, and this is a fairly common scenario, and it gets confusing to people, and it certainly confused the IRS in this one. But many farmers have a practice of deferring grain sales, as well as pre-purchasing inputs, prepaying inputs. And what you had in this situation was Dad, who was the farmer, was a sole proprietorship situation, mom and dad operation in Nebraska, just south of Lincoln, Nebraska a little bit. And Dad prepaid $235,000 worth of crop inputs in the fall and wrote it off on that year's tax return that was filed March 1 of the next year. Before he put the crop in the ground, guess what he did? Died. It's already been deducted on the return that was filed just a couple of weeks before he died. And the return was filed March 1. He died March 15, hasn't used the $235,000 worth of seed, feed, fertilizer to put the crop in the ground. Everything passes to Mom. So what's Mom do? Uses the inputs to put the crop in the ground, and then on her return for that year, writes off $235,000. Again, IRS's head explodes on this. You can't take a double deduction. That's not a double deduction, because what happens, and this is why the step-up basis rule is so important, because when Dad died, that was part of the inventory in his estate, gets revalued at death, goes to Mom, she writes it off again. That's the way the code works. Deduct it, basis increase, deduct it again. If you eliminate the basis rule, that's a totally different income tax result for Mom. She doesn't get to run it through again.
There's so many different business arrangements with our farming operations, and there's a lot of times a buy-sell type of agreement. Are there different tax considerations for those as well? Yeah,
there are basically 3 or 4 different types of buy-sell agreements. And frankly, I think a buy-sell agreement is probably as important as the will or the trust, the well-drafted will or a trust. The buy-sell is critical, particularly if we're interested in transitioning the business from the current generation to the next generation. And there are various types. We could have a straight-up redemption agreement where your shares are just going to get redeemed. We could have a cross-purchase agreement, and those have different tax connotations to them. And again, there are basis issues that are involved in that. And then another issue with a buy-sell is how they're funded. Often they're funded with life insurance, but a buy-sell is only as good as there are funds to buy the interest out of the decedent or whatever triggered the buy-sell in that instant. Often it's at death. And it's used to get the ownership control interest into the hands of the on-farm heir and cash to the off-farm heirs. It's only as good as it is funded. But yes, there are different types of buy-sells. Farmers and ranchers need to be talking to their CPAs, their attorneys, to make sure they get one that is structured best for them.
Are there any other common issues along that, commonalities you see in some of those type of, say, a succession type of situation for taxes?
There are commonalities on, I would say, on the positive side and on the negative side. Let's start on the negative side. Some of the worst things you can do if you want to transition the business successfully in the next generation is leave your land equally to all of your kids, an undivided interest. That won't work in many instances because often the off-farm heir is going to want to cash out, and so they can force a partition and sale, and nobody's going to be happy with that. Another plan that some people will say is, I'll just let the kids figure it out. You're going to let a judge figure it out is what's going to happen. That's not good. Those are some common problems that I see. We don't, and another one related to a common problem was is I just don't know where to start. And so not knowing where to start, I don't start. Or they'll say, I'll do it someday. Well, we don't know how much sand is in the top of our hourglass. And so the sooner you can get started on transition planning and then also putting some type of plan in place to make sure you're covered in the event of long-term health care, that can eat up, if you have to use public assistance benefits at $8,000, that can eat away at your capital base in your farming or ranching operation. So that can eat away at your capital base in your farming or ranching operation. So those are commonalities on the downside. On the upside, if we're structured correctly, the proper structuring of the business, proper income tax planning, those are good commonalities that can go a long way to making sure the operation survives into subsequent generations.
I'm going to switch back to some law issues. Your program airs on our network twice each day, and I always love the quick snapshots. You give us a lot of legal issues. A lot of things are happening at the state level when it relates to agriculture. Can you kind of shine a light on some of the cases that you've been talking about?
Just the one, actually, it's airing today. If they're played in order, the one that is airing today is a hog nuisance case out of Kansas. And I think we just had this come down from the Court of Appeals, and frankly, I think it's probably the worst nuisance case we've had in Kansas that I can recall or that I've ever read. And what it involved was a farmer that expanded a hog operation and, of course, needs to deal with the waste from the hogs. And he thought he had a great idea because he owned farmland 2 miles down the road past 2 other farms, that he would just lay pipes, bury pipes in the road ditch in front of his neighbor's fields for 2 miles, run 2 water lines to his hog operation and 1 effluent line back to an pivot irrigation arm he's got that comes within 200 feet of a neighbor's farmhouse. He doesn't get permission from the neighbors to do this. He doesn't get permission from the county. County attorney tells him you can't do this without permission. He lobbies the legislature for permission. The legislature bill didn't go through the legislature. He does it anyway. County attorney sends the sheriff out. Sheriff tells him to stop. He doesn't stop. He pumps this through to his irrigation arm. He's got a gun on the end of it where he's spraying it through the gun hose on the end, plus the drip irrigation. Wind catches it, plasters the neighbor's house. The neighbor's wife opens up the door, not realizing that the wind was blowing that. She's covered, and she said, I'm out of here, I'm moving to Nebraska. He gets sued, and the court came down and said, it's a nuisance. You can't use the right to farm law because you're trespassing, which gave rise to the nuisance, so you're in violation of state law. Not only do you have to pay economic damages, we're going to hit you with punitive damages too for being stupid. Don't do that stuff. It's just amazing, some of these cases you see. It's what are you thinking when you do these things? You're not. But you know, the nuisance cases, the lease cases, outside of tax and estate planning and business planning, I'd say I get more questions on leases and fences than anything else. Make sure you have good fences to avoid problems with your neighbors, adverse possession issues, easement issues. They're all over the place in agriculture.
Boundary lines, those kind of things.
Boundary lines.
Yeah. You mentioned nuisance cases, and it just seems like, obviously in agriculture, a hog operation may have some odor associated with those kind of things. Those things inevitably end up in courts and neighbor against neighbor.
Oh, they do. The classic hog nuisance case that I teach my students, because it's so illustrative of the ridiculousness of how some of this stuff can get, was from Stowe, Vermont, of all places. If you've ever been to Stowe, Stowe is a tourist town. It's beautiful. It's not the town itself. It's not agriculture, but of course it's a rural area. It's a small town. But back in the 70s and 80s, in Stowe, you can't have motels that are of large size. You can't have chains. It has to be all mom and pop stuff. And of course, they don't have. It's like parts of North Dakota. They don't have air conditioning. And so the windows are open all the time, summer around. And there was a guy that owned an acreage in town, and he wanted to put up a motel. Well, the neighboring motel, he wanted to put up a big one, and they opposed him. And so he got upset with this, and on his couple of acres that he had in town, he started a hog farm. because the existing ordinance didn't bar having hogs in the center of Stowe, Vermont. Now, whoever wrote the ordinances screwed up, wasn't thinking that one through, so he got his permit to start a hog farm in Stowe, Vermont. But he didn't do it in an orthodox way. He brought the hogs in and then he didn't feed them. And then he brought chickens in and didn't separate the roosters from the hens and didn't feed them, and they pecked each other to death. The hogs died, the chickens died. He just let them lay there. Then he brought in 16 wet semi-loads of chicken manure, dumped it, piled it 4 feet high, right across from his on and on it goes. Rusty water tanks. Just created a disaster. Of course, he gets sued for nuisance, and he got hit with all kinds of financial penalties. And he was saying, well, I have a permit to do that. I'm in compliance with the zoning laws. Yeah, but you're still a nuisance, and you did it deliberately.
Don't piss off your neighbor, I guess.
I thought of that case when I was reading the Kansas case. It's like, what, was this guy related to the fellow from Vermont? I mean, it's just, some of that stuff is just crazy.
Oh,
yeah.
What are some of the other cases that you've been talking about? It seems a lot of the state issues go.
Well, it was actually a federal, it was a U.S. tax court case, but it involved a farmer in southwest Iowa, and the decision just came down last December, early December. And you'll get a kick out of this one. We have lost a lot of the good farm auditors and IRS through retirement over the past decade, 10, 15 years. And we just don't have experienced IRS auditors with respect to farms anymore. And we struggle with some of the positions that they take, like this case in Nebraska I mentioned. That should have never gone to court. Of course, you can deduct the prepaids, and if he dies with them in the inventory, you get a step-up basis. Mom runs them through again. That was an easy win for the farmer, but he had to litigate it. Here was a farmer that graduated from college in about 72, 73, gets married, moves his new bride into the first farm that he bought, an 80-acre tract that had the farmhouse on it, so it's got the homestead on it. And then over the years, he's working full-time as a UPS route driver. So as many farmers would do that has an off-farm job, what he would do is he would farm for a couple hours before he'd go to town to get in his truck to drive the route throughout the day, and then he'd come home, have supper, and farm till midnight. The court said he did this year after year, decade after decade. And he'd acquire farms. He'd get a 40-acre tract here, another 80 tract, and another 80 here. And by the time this got to the tax court, he had 5 tracts, about 500 acres. I think it was 6 tracts, about 500 acres. And they're spread 12 to 14 miles apart. They're not contiguous tracts. He just bought the land when it became available. He farmed through the 80s and with old tractors, and he would park tractors at each of these particular farms, and he would hook them up to implements that he was going to use on those farms. So by the time this got to court, he had over 40 used tractors, the newest of which was 35 years old. And he farmed with old tractors because he could repair them. They didn't have all the electronics on them, and the most expensive one, as I read the list in the tax court case, was about $8,500 that he ever spent on a tractor. And the court said he was successful. This was his method of farming. He made it through the farm crunch of the 80s. He kept his repair bills down. He did his repair work himself. And the IRS came in and audited him, and at first started to argue that he was a hobby farmer and gave up on that argument, but still denied all of his expense deductions associated with farming because they said, we know what you are and you're not a farmer. You're an antique collector.
Well, there's a lot of antique collectors out here.
And and it was my tax law professor in law school that represented the farmer. And I talked to him in May when I saw him, and I was asking him, what in the world was going on with the IRS examining agent out of Des Moines? He said, she just wouldn't come off of this position, and her supervisor wouldn't take her off this position. We end up in tax court. Of course, he wins. You can farm the way that you want to farm. It's a 40-page opinion where the judge just explains that farming to the IRS. It's funny to read, but you get ridiculous positions like that. But that's on the tax side of things. That's an interesting one that occurred last fall.
Yeah, it sounds like it. You got a question back there, Sierra?
Good morning. How does adverse possession affect abandoned rail lines?
How does adverse possession affect what?
Abandoned rail lines.
Oh, abandoned rail lines. Well, when you have I assume you're talking rails to trails, where a line is abandoned and now you've got some type of group that comes in and wants to put a trail in. We've got a couple issues to deal with on that one. And the overriding issue on that is, what was the interest that the railroad held? What was the legal property interest that the railroad held? Did they own the line in what we call fee simple absolute? Did they own it outright? Or did they just have an easement to run the line? If they owned it in fee simple absolute, then they can designate whoever gets the abandoned corridor. If all they had was an easement, then when they abandoned the use of that easement to operate a rail line, then that rail line would revert back, that abandoned corridor would revert back to all of the adjacent owners along the line. So the first place you have to start is to determine what was the legal property interest that the railroad had. A lot of them were easements. And then you look to state law to make sure that there's a reversion back to the adjacent owners, and in many instances there will be. There have been 2 significant U.S. Court of Federal Claims cases in the past year and a half on that particular issue, and the landowners won those cases and were entitled to compensation because the trail group got the land and it should have reverted to the owners, and that was deemed to be a taking requiring compensation under the Fifth Amendment. So the first step analysis is to determine what type of property interest the railroad had.
Talked about cases earlier. Where are we sitting with all the glyphosate cases that Monsanto Bayer had been involved in?
You want the status of the cases? Well, those are ongoing, and we still have a couple of different dimensions. We have the Roundup side of things, and there's still a lot of cases in the pipeline on the Roundup side. And then we have the dicamba cases with respect to dicamba drift, which have largely come out of the big cases out of Missouri, the boot heel of Missouri on the large peach farm operation. And there still is some dicamba cases out there. Now, farmers are winning the dicamba cases where they've had drift that have ruined their crops. That's been an issue with the change in the type of dicamba and the volatility of it, and the USDA kind of getting ahead of the regulatory process and getting something out there that then farmers didn't follow the label and then causing drift. Some states have come in, such as Arkansas, and have put in restrictions as to the timing of year when you can apply dicamba, buffer zones, those types of things. But so we have cases still out there in the dicamba pipeline as well as the Roundup pipeline.
Do you see certain trends happening in some of these cases that are associated with agriculture? Is there anything in particular?
Well, I think the trend has worsened with respect to at least in my mind, worsened with respect to greater regulation of farming activities, particularly at the federal level. Now, that is cyclical depending upon what type of administration is in power and what their policy is in general, whether we have a pullback or whether we have greater regulation. So that's a trend that's tied to the politics. And at some state levels, you can see that too, but it's not as pronounced at the state level as it is sometimes at the federal level. So that can be a trend. Now, if you look at a 40, 50-year trend, definitely greater regulation of agricultural activities, whether that's Endangered Species Act or Clean Water Act or basically any type of federal regulation that touches agriculture. Some of the things out west we're dealing with now with the Bureau of Land Management, big issues out west. I just finished a major conference in Idaho, and they have some real issues going on with the BLM out west on grazing lands, and other non-agricultural interests now being able to utilize the grazing lands, which is upsetting the ranchers that have their allotments. So the regulation aspect is big. Water out west is huge. The water rights issues. We had a Navajo Nation case come through the Supreme Court, and it involved whether the reservations have an absolute right to a certain amount of water or not. The Supreme Court said no, they don't. But water rights are going to continue to be big, particularly in the West. You get the urban-rural conflict on water use.
We're running close on time. If folks want to find out some of the cases you're following, those kind of things, I think you have a blog. And
I do. I am on my website, which is washburnlaw.edu/WALTR. And then my blog is accessible on the homepage of that, down the left-hand side. And if you're listening daily to the radio program, I summarize in a minute some of these issues I'm talking about. And you can always contact me either through my website or let Don know that you have a question and get in touch with me that way.
It's a great show. We appreciate it. Again, Roger McOwen with us from the Washburn University School of Law in Topeka, Kansas. We appreciate you making the trip north and being with us today.
Thank you. Appreciate it.
We thank you for joining us, and stay tight. We've got markets coming up in just a second, and then Ag Country Farm Credit Services, Rob Froning is going to be on stage here in just a second as well. So stay with us here on the Red River Farm Network.